Welcome back, everybody. If you're new to the channel, I'm Ryan Keeney and I'm a lawyer in Ontario. The topic of today's video is how does child support work in Ontario? I've placed timestamps in the description of this video so you can jump ahead to any specific subtopics that you want to quickly review. I've also included links to several court cases that are relevant to our subject today. I should mention that if you're just starting your journey into learning about how child support in Ontario works, this is a topic that can get fairly complex, which you might have already noticed just from the length of this video. On the bright side, I believe that anyone with enough determination can learn exactly how child support laws work in Ontario. I've tried to explain the information in as plain language as possible while still going into a pretty significant amount of detail. Now, whether you're a law student, junior family lawyer, or you've never been to law school, I'm confident that you'll learn a lot through this video and you'll be able to understand the basic principles that I'll be discussing. First and foremost, it's important to keep in mind where we actually find the laws regarding child support. Like in most types of law, it comes down to two places. The first source of our law is legislation, which is written by different levels of government. Most Ontarians are already aware that Parliament in Ottawa write our laws at the federal level of government, and of course, the Ontario legislature writes the laws at our provincial level in Ontario. Both of these levels of government have created legislation that deal with child support. Okay, so the second place we find our laws is what lawyers call common law, or another term you might be more familiar with is case law. So why do I mention these two sources of law? Well, throughout this video, I'm going to make reference to a lot of specific sections of legislation, and I'm also going to talk about different cases where judges have made decisions in Ontario. Those cases are part of our case law, and that largely determines how we treat future cases. Okay, so now that you know about where our laws come from, let's jump into how child support is actually calculated. Although a number of factors can influence a judge's final decision, which I'll talk about later in this video, for the most part, child support is often determined by what lawyers call table amounts. The name comes from the fact that the government has created legislation with illustrated tables where people can easily calculate their child support obligations based on their annual income, the province that the paying parent lives in, and the number of children that they have. At the Canada-wide level, these tables can be found in the Federal Child Support Guidelines, Regulation Number S.R./97-175. And in Ontario, we have Ontario Regulation Number 391/97, also known simply as the Child Support Guidelines. Now, don't get too intimidated by those citation numbers, and you shouldn't feel like you have to memorize them. The important thing for you to keep in mind is that the federal child support table amounts in the federal guidelines are the same as the ones in the Ontario guidelines. The laws were simply written by two different levels of government. Moreover, you don't actually have to look up the table amounts yourself, since there are some great calculators available online, one of which I'll talk about in a moment. After you finish watching this entire video, you'll understand why simply plugging in some basic information into an online calculator is simply not a replacement for having a lawyer in court. And no online calculator can predict with 100% certainty what a judge will actually do with your specific case. That being said, if you are going to use an online calculator, I've personally heard very good things about MySupportCalculator.ca. To be clear, they've not sponsored this video and they have not paid me anything to mention them. I'm mentioning this calculator simply because this is the calculator that I hear most often mentioned amongst my colleagues in the legal profession. If you look at their website, they also have comments from former family court judges with positive things to say about them. But remember, even MySupportCalculator.ca says on their website, quote, "This calculator is intended to provide a starting point for child and spousal support calculations only, to be adjusted in accordance with the many other factors not considered by this calculator that could dramatically affect these results. Calculations from this site are not legal advice and are not a substitute for working with a family law professional." So now that you know a little bit about how child support is generally calculated, let's talk about who is responsible for paying child support. Obviously, most people are already aware that biological parents have obligations to support their children. But what about step-parents? A lot of people in Ontario are unaware of the fact that step-parents can also be required to pay child support under the law. Let's take a look at the legislation and the case law that explains this obligation. One of the important pieces of legislation that governs family law in Ontario is the Family Law Act, or FLA for short. Section 1 of the FLA says that the definition of a parent includes a person who has demonstrated a settled intention to treat a child as a child of his or her family, except under an arrangement where the child is placed for valuable consideration, and that means money. Valuable consideration is usually money. For valuable consideration in a foster home by a person having lawful custody. Section 1 of the FLA also says that the definition of a child includes a person whom a parent has demonstrated a settled intention to treat as a child of his or her family, again with the exception for foster children. Notice that the definitions don't say anything about having a biological relationship with the child. The question of whether or not a step-parent should have to pay child support was an issue that went to the Supreme Court of Canada back in 1999 in the case of Chartier versus Chartier. In that case, the Supreme Court said, quote, "Even if a relationship has broken down after a separation or divorce, the obligation of a person who stands in the place of a parent to support a child remains the same." When a judge is deciding whether or not it appears that a person was standing in place of a parent, as step-parents often do, courts will look at the following factors: whether the child participates in the extended family in the same way a biological child would, whether the person provides financially for the child, depending on the ability to pay, whether the person disciplines the child as a parent, whether the person represents to the child and to the family and to the world that he or she is responsible as a parent to the child, either explicitly or implicitly, and the nature or existence of the child's relationship with the absent biological parent. Regardless of whether a support payer is a step-parent or a biological parent, one of the important factors in determining child support obligations is how much time is spent with the child. Generally, child support is paid by the parent that spends the least amount of time with the child to the parent who takes care of the child most of the time. However, what if each parent spends at least 40% of their child's time with them over the course of a year? This is what the law calls shared parenting time. If that is the situation, then you'll need to look at Section 9 of Ontario's Child Support Guidelines. Section 9 basically says that in cases of shared parenting time, where each parent spends at least 40% of the child's time with each parent, then judges must consider the following three factors when deciding child support obligations. First, the amounts set out in the applicable tables for each of the parents or spouses. Remember the table amounts I mentioned earlier in this video? If you forgot, you can always go back and watch that again. Second, the increased costs of shared parenting time arrangements. And third, the condition, means, needs, and other circumstances of each parent or spouse, and of any child for whom support is sought. If you want to take a really deep dive into how the courts will interpret Section 9 of the guidelines, I recommend reading the Supreme Court of Canada case called Contino versus Leonelli-Contino, and you can find a link to that case in the description. Okay, let's take a look at another typical scenario that can shift the balance of who pays child support and how much. The scenario I'm about to explain is called split parenting time. And this happens if there are two or more children and each parent has the majority of parenting time with respect to one or more of those children. So for example, let's say you've got a son and a daughter, and the son spends most of his time with dad and the daughter spends most of her time with mom. In that case, how would the child support obligations look like? Section 8 of Ontario's Child Support Guidelines basically says that the amount of child support is the difference between the amount that each parent would otherwise pay if they both claim child support against each other in a situation like this. So let's put that into plain English. In the example I mentioned, let's say the father says, "I want child support for my son because he's with me most of the time." But the mom also says, "I want child support for my daughter because she's with me most of the time." In that case, a judge would have to determine whose child support claim is larger, and then that person would get some money based on how much larger their claim is. So if I owe $200 per month in child support, but I'm also entitled to receive $300 per month in child support, I just end up receiving $100 per month in child support. This is probably a good point of the video to mention that child support is the right of the child. So although the money is received by the recipient parent, it's the best interest of the child that is the focus when determining child support. I know that might sound confusing, but this is a fundamental principle in family law. Child support is not the right of the parent, it is the right of the child. Okay, if you've made it this far in the video, you now know quite a bit, like the difference between legislation and case law, how child support is calculated, who's responsible for paying it, and certain situations that can alter the calculations. But no video tutorial about child support in Ontario would be complete without a detailed description about what lawyers like to call Section 7 expenses. As you might have noticed by this point in the video, lawyers like to refer to certain laws by their section number in the legislation in which they're found. So when I use a phrase like Section 7 expenses, I'm referring to Section 7 of Ontario's Child Support Guidelines, which is the legislation that I mentioned earlier. So what are Section 7 expenses? In a nutshell, these are special or extraordinary expenses that a court can order a support payer to pay over and above the table amounts that I described earlier in this video. Typical examples of Section 7 expenses are things like fees for extracurricular activities like dance classes, piano lessons, sports-related expenses, and any number of other extracurriculars. But Section 7 covers a lot more than just extracurricular activities. The court can also order payment for childcare expenses incurred as a result of the employment, illness, disability, or education or training for employment of the parent or spouse who has the majority of the parenting time, or a portion of the medical and dental insurance premiums attributable to the child, or health-related expenses that exceed insurance reimbursement by at least $100 annually, including orthodontic treatment, professional counseling provided by a psychologist, social worker, psychiatrist, or any other person, physiotherapy, occupational therapy, speech therapy, prescription drugs, hearing aids, glasses, and contact lenses. It could also include extraordinary expenses for primary or secondary school education or for any other educational programs that meet the child's particular needs. It could also include expenses for post-secondary education. And yes, you heard that last one correctly. Parents can be required to pay child support even when your child is in college or university and is no longer a minor. There's a common misconception that all child support stops when the child becomes a legal adult, but that's not true. People who are under that misunderstanding probably just aren't aware of Section 7 expenses. Now, when a judge is deciding whether or not to order a parent to fully cover, partially cover, or not cover at all any of these expenses that I mentioned, the law requires judges to take into account the following factors. 1, the necessity of the expense in relation to the child's best interests. 2, the reasonableness of the expense in relation to the means of the parents or spouses and those of the child. And 3, the spending pattern of the parents or spouses in respect of the child during cohabitation, which means while the family was still previously living together. Okay, so I'm going to spend some time addressing what happens if the person paying child support has an annual income of over $150,000 per year. So if this doesn't apply to you, then you might want to use those timestamps in the description that I mentioned earlier and skip ahead to the next section. On the other hand, if you think this information might be relevant to you or someone you know, then let's get into it. Section 4 of the Child Support Guidelines deals with situations where the parent responsible for paying child support has an annual gross income of over $150,000 a year. I'm going to display Section 4 on the screen for you now, but fair warning, like most pieces of legislation, the language is not written in a very user-friendly way. So I'm going to be translating it into plain English for you. What Section 4 is basically saying is that judges have options and are entitled to exercise some degree of discretion when deciding what to do with situations where the support payer is earning this range of income. Subsection 4A says that judges could simply just use the table amounts that are already found in the guidelines, plus any Section 7 expenses that I described earlier in this video. However, because this might result in a child support payment that is inappropriate, either because it is too large or too small, judges can also use an alternative approach described here at subsection 4B. This is actually what happened in the case of R versus R at the Ontario Court of Appeal back in 2002. The case records don't disclose the parties' last names, so we're just going to refer to them as Mr. and Mrs. R. In that case, Mr. and Mrs. R separated after 8 years of marriage. In the last 5 years of the marriage, the husband's annual income averaged $1.4 million per year. After separation, his income doubled to $4.1 million per year. Under the federal child support guidelines, the table amount of child support for 4 children at that income was over $65,000 per month. Like I mentioned before, under Section 4 of the guidelines, if the paying spouse has an income over $150,000 a year, the court may substitute an amount that it considers appropriate if it concludes that the table amount is inappropriate. The trial judge declined to award child support for 4 children in the guidelines table amount. The judge found that the family lifestyle before separation was conservative and modest. The judge decided that the children would have continued to enjoy a comfortable but not extravagant lifestyle had there been no separation. This meant the trial judge felt that the table amount was inappropriate. He ordered the husband to pay $16,000 per month for the 4 children instead of $65,000 per month. The wife was not particularly pleased with this outcome, so she appealed the trial judge's decision to the Ontario Court of Appeal. The Court of Appeal partially agreed with the wife. The Court of Appeal agreed with the trial judge that the table amount of $65,000 per month would be inappropriate, but decided that an appropriate amount of child support in this case should have been a total of $32,000 per month to care for the 4 children. So, this new amount was ultimately ordered by the Ontario Court of Appeal. The case of R versus R is still used in courts today, 20 years later, and among other things, it illustrates one example of how judges may deviate from the table amounts when dealing with cases of high income earners. This is one example where online calculators and formulas would not have been helpful. Before we leave this subject, I'll mention one more case. In the 1999 Supreme Court of Canada case known as Francis versus Baker, similar issues were addressed, but the case had a different outcome. In that case, the parties were married in 1979. At that time, the husband was employed as a lawyer in a large Toronto law firm, while the wife worked as a high school teacher. The party's firstborn child was born in 1983. The husband left the family in 1985 when their second child was 5 days old. The wife returned to work full-time 3 months later. Parties divorced in 1987. In 1988, the wife applied to the court for an increase in child support. At trial, 9 years later, she changed her case to include a claim for child support pursuant to the then new federal child support guidelines, which were to come into effect shortly and were intended to apply to all pending child support orders. Talk about good timing. The wife earned $63,000 per year at the date of trial. Under the terms of a separation agreement, she also received $30,000 per year in child support payments from the husband. The husband earned $945,538 per year, and his net worth was estimated to be $78 million. The trial judge exercised her jurisdiction under the Divorce Act to award the respondent the table amount of child support applicable to the husband's income, or $10,034 per month for both children. That worked out to $120,408 per year in child support. The husband appealed this decision to the Ontario Court of Appeal, but his appeal was dismissed. The husband then appealed to the Supreme Court of Canada, and his appeal was dismissed again. The Supreme Court said, quote, "The appellant is in effect asking this court to impose a cap or upper limit on child support payments. Parliament did not choose to impose such a cap, and the appellant has advanced no reason why this court should do so. For these reasons, the appellant's sheer size argument fails to convince me that the trial judge abused her discretion in awarding the table amount on the facts of this case." To read the full reasons why the various appeals failed and the courts refused to reduce this wealthy individual's child support payments, you can check out the links to these cases in the description. Okay, in this next part of the video, I'm going to be addressing another typical child support issue that comes up a lot, and it has to do with determining the income of a support payer. Let's say you've got a situation where a parent or a spouse is intentionally unemployed or underemployed, or they're earning cash under the table, which they don't declare as income. There's a lot of ways that people try to reduce their child support obligations, and they usually think that their creativity to avoid these obligations will work. But the legislation and the courts have processes in place to stop this type of behavior. In fact, under Section 19 of the Child Support Guidelines, judges can do something called impute income, which means that they will make conclusions about what a person's true income actually is or what it should be, despite the fact that people are trying to artificially lower their income. If you take a look at the list outlined in Section 19, you'll see that there are 9 situations where imputing income can happen. First, the parent or spouse is intentionally underemployed or unemployed, other than where the underemployment or unemployment is required by the needs of any child or by the reasonable education or health needs of the parent or spouse. Second, the parent or spouse is exempt from paying federal or provincial income tax. Third, the parent or spouse lives in a country that has effective rates of income tax that are significantly lower than those in Canada. Fourth, it appears that income has been diverted, which would affect the level of child support to be determined under these guidelines. Fifth, the parent's or spouse's property is not reasonably utilized to generate income. Sixth, the parent or spouse has failed to provide income information when under a legal obligation to do so. Seventh, the parent or spouse unreasonably deducts expenses from income. Eighth, the parent or spouse derives a significant portion of income from dividends and capital gains or other sources that are taxed at a lower rate than employment or business income or that are exempt from taxes. And ninth, the parent or spouse is a beneficiary under a trust and is or will be in receipt of income or other benefits from the trust. When it comes to what the case law has to say about Section 19 of the Child Support Guidelines, 2 very often cited cases in Ontario are Drygala versus Pauli and Lavie versus Lavie. Both of these cases came from the Ontario Court of Appeal, which is Ontario's highest level of court. I've included links to both cases below, but for the sake of time and convenience, I'm only going to discuss the details of the Drygala case. This case is important because it helps judges and lawyers understand how to deal with cases where either the child support payer or the child support recipient is unemployed or underemployed for reasons related to pursuing educational goals, and the court needs to impute income for the purposes of calculating a fair amount of child support. You might remember a moment ago when I listed out those 9 situations where income can be imputed. This case deals with the first item in that list. Okay, so here's the facts of the Drygala case. The husband earned $21 per hour as a certified tool and die maker. After the parties separated, he did not look for any employment. He was on the payroll of his stepfather's company for the years 1997 to 2000, but substantial portions of his income were retained by the company to reduce his alleged indebtedness. In 2000, the husband enrolled as a full-time student in a Bachelor of Arts program with the goal of becoming an elementary school teacher. He was substantially supported by his mother. The parties were granted a divorce in 2001, and he was ordered to pay child support for the parties' one child in the amount of $266 per month based on an imputed annual income of $30,000. In imputing income to the husband, the trial judge relied on Section 19 1A of the Child Support Guidelines. Child support was ordered retroactively, which is something we'll talk about later, to June 15th, 1998, the date of the original petition for divorce. The husband appealed the trial judge's decision. The Ontario Court of Appeal granted the appeal in part. Although the appellate court agreed with most of the trial judge's reasoning, the Court of Appeal decided to reduce the imputed annual income from $30,000 to a lower amount of $16,500 per year. To be clear, that's not the child support payment, that is what his imputed annual income would be assumed to be. Like I mentioned before, if you want to read the full analysis regarding how the appellate court arrived at its decisions in either the Drygala case or the Lavie case, check out the links in the description, but for now, let's move on to the next topic. Whether you're paying child support or you're receiving child support, it's important to know what retroactive child support is. This concept is exactly what it sounds like. Judges have the power to order people to retroactively pay child support to make up for any period of time in the past where the support payer should have been paying support but was not. Judges can also do this where the support payer was making payments but was paying a smaller amount than what the recipient was entitled to under the child support guidelines. This concept also applies when the support payer sees their income go up but does not increase support payments to the new table amount. Basically, even if a support payer has been getting away for years with either not paying or paying too little, courts can still look far back into the past and slap a large bill on the support payer. However, it's important to keep in mind that the parent receiving child support money is expected under the law to actively pursue child support and any increases to which their child are entitled to. If you take a look at Section 25 of the guidelines, a support payer must, upon written request by the support recipient, disclose information about their current income. If the recipient parent knows or thinks the payer has increased their income, then he or she can apply to change the child support order and have that new order apply retroactively. So when determining whether or not it's appropriate to issue a court order regarding retroactive support, a judge will consider the following factors. 1, the reason for the delay on the part of the recipient parent in seeking support if there was any delay. 2, whether or not there was blameworthy conduct by the paying parent. And 3, the circumstances of the children or the child. And 4, the potential hardship to the payer. These 4 factors come from 4 different appeals to the Supreme Court of Canada, which the court heard together and developed a framework for addressing all 4 appeals and any similar cases in Canada in the future. Quoting directly from the Supreme Court, the court had this to say: in determining whether to make a retroactive award, a court should strive for a holistic view of the matter and decide each case on the basis of its particular facts. The payor parent's interest in certainty must be balanced with the needs for fairness to the child and for flexibility. In doing this, the court should consider the reason for the recipient parent's delay in seeking child support, the conduct of the payor parent, the past and present circumstances of the child, including the child's needs at the time the support should have been paid, and whether the retroactive award might entail hardship. The court also goes on to put a limit on how far back into the past judges should go when making orders about retroactive child support. Basically, the limit is 3 years into the past, but there can be exceptions to that time limit if there was blameworthy conduct on the part of the support payer. I don't want to oversimplify what the Supreme Court said about retroactive child support, so if you're a law student, lawyer, or litigant involved in a family court case and you want to have a really clear understanding of exactly how the Supreme Court designed the legal framework for retroactive child support cases, I highly recommend that you follow the link in the description and read the Supreme Court's decision in the 4 appeals. For your convenience, I've displayed the case citations on the screen now, and you can pause the video if you like. Okay, so congratulations on making it this far in the tutorial today. I know we've covered a lot, but the next topic is going to be of particular interest to people who pay child support, but it could also be something to keep in mind for people who receive child support. The topic for this next section of the video is undue hardship. Although the law is very strict when it comes to making sure that children receive financial support from their parents, this strictness is balanced by the fact that support payers can raise legal arguments about undue hardship that they might experience so that a fair child support order can be made. Section 10 of the Child Support Guidelines goes into detail about how the law regarding undue hardship works. Before I start quoting from Section 10, I want to make one quick comment about how paragraphs are organized in legislation. It's very common that a particular section will have many subsections. For example, I might say something like Section 10, subsection 2, or Section 10, subsection 6. This can sound confusing if you're not dealing with legislation all day long, but if you can get comfortable understanding the different subsections of a particular law, you'll get a much better insight into how that law works. Okay, so let's take a look at Section 10 now. The wording of Section 10 says, on the application of either spouse or an applicant under Section 33 of the Act, a court may award an amount of child support that is different from the amount determined under any of the sections 3 to 5, 8, or 9, if the court finds that the parent or spouse making the request, or a child in respect of whom the request is made, would suffer undue hardship. That might sound like a lot of confusing legal jargon, but the basic idea is that the judge has the discretion to change the amount of child support if the support payer would suffer undue hardship, or if a child would suffer undue hardship. So the question you might be asking at this point is, what constitutes undue hardship? Subsection 2 within Section 10 contains a list of legally recognized circumstances that might cause undue hardship, and I've displayed them on the screen now. Some of the typical reasons for undue hardship is certain kinds of debt, unusually high expenses due to parenting a child, having family court obligations to another person, such as if a person has multiple child support payments from multiple relationships, and a few other reasons. It's very important to keep in mind that even if you successfully convince a judge a certain level of child support would cause undue hardship, the judge still has the discretion to deny the request to lower the child support payment, and this is addressed in subsection 3 within Section 10. This particular subsection says that, quote, despite a determination of undue hardship under subsection 1, an application under that subsection must be denied by the court if it is of the opinion that the household of the parent or spouse who claims undue hardship would, after determining the amount of child support under any of sections 3 to 5, 8, or 9, have a higher standard of living than the household of the other parent or spouse. Now let's say you're a support recipient and you're not quite happy about your support payer claiming undue hardship, and let's say that the judge agrees with the support payer. You're probably going to be even more unhappy. Fortunately, subsection 6 within Section 10 says that where the court makes an order for the support of a child in a different amount under this section, it must record its reasons for doing so. That might not sound very helpful, but when you have written reasons from a judge, it can help your lawyer look for any grounds for appeal and perhaps have that decision reversed at a higher level of court. Okay, so it's all well and good that a family court judge has decided your case and gone through a tremendous amount of legal analysis to determine a fair and reasonable amount of child support. But that still leaves one practical problem. How do you actually enforce child support? After you get an order for child support from a judge, child support is enforced in Ontario through the Family Responsibility Office, otherwise known as FRO. They're able to carry out their duties under the authority of the Family Responsibility and Support Arrears Enforcement Act of 1996 and the Interjurisdictional Support Orders Act of 2002. FRO plays an important role in ensuring the financial security of families who count on court-ordered support. They collect payments from the person who pays the support, and they send those payments to the person who is entitled to it. However, it's important to keep in mind that FRO does not make payments to a recipient when the payer misses a payment. They cannot change the terms of court orders or domestic contracts, including the support amount, and they cannot get involved in child custody or access issues. People are often surprised at just how much power FRO has to enforce child support orders. For example, they can take the money directly out of your bank account, and this is known as garnishing. They can report an unpaid child support debt to a credit bureau. They can suspend your driver's license. They can put a lien on your property, seize real estate that you own, report you to your professional regulatory body or occupational organization. FRO can even go to court and ask a judge to order a support payer to spend some time in jail for failing to cooperate. Practically speaking, FRO encourages people to work cooperatively with them before escalating to more aggressive enforcement steps. FRO encourages support payers to reach out and contact them to avoid enforcement actions if your financial situation changes, such as due to losing your job, you fall behind on your payments, your name, address, or employer or source of income changes, or you believe that your obligation to pay support has lawfully ended. Remember, the proper place to make changes to child support orders is in court, not through FRO. But there is some reasonable amount of flexibility available through their office. Speaking of making changes to child support, that's going to be the topic of the next section of this video, so let's get into it. The process can look quite different depending on whether or not the support payer and the support recipient agree to the change. If they can agree, then they can make an agreement. The agreement must be signed and dated by both parents and a witness. If the new agreement changes an old agreement that was filed with the court, or a notice of calculation, or a notice of recalculation, then any new agreement should also be filed with the court. If it's not filed with the court, the Family Responsibility Office cannot enforce the new support amount. If the new agreement changes a final court order, the parents need to ask the court to change their order based on their new agreement. In some cases, parents can use the Online Child Support Service, CSS, to change child support. Based on new income information, CSS sends the parents a notice of recalculation that tells them how much child support must be paid. However, you cannot use the service if you used CSS to decide or change child support less than 6 months ago. You can visit the link in the description, scroll down the page, and click on the Setup or Update Child Support button. Remember, this service is not available to everyone. After you visit the website that I've linked, you'll be able to verify whether or not you're eligible to use this service based on your case. Okay, let's say the support payer and support recipient can't agree on the change. Then, your two most common options are going to be, well, going online to CSS or going to court. If you're eligible to use CSS, then you might be happy to know that only one parent needs to ask to change child support online. The other parent does not need to agree. They will simply get a notice in the mail from the Ministry of the Attorney General that says that the other parent applied to change child support online, and CSS agrees that it can make the change. The paying parent can disagree if the information the other parent gave was wrong, but if they do not respond within 25 days of the notice being sent, CSS might change their support payment without their response. The second option is to go to court using a process called a motion to change, and I would highly recommend using a lawyer for this process. Unless the other parent agrees, the court can only make changes if there has been a significant change or what the law calls a material change in circumstance. For example, if the payor parent's income has gone up or down, the child has left the parent's house voluntarily, the child is now living with the payor parent, the child is no longer in daycare or full-time school, but those are the most common reasons. Now, a change in the income of the parent receiving support is usually not a reason to change the child support order. This is because that parent's income is not usually taken into account when support is calculated. Well, congratulations on making it to the end of this overview of how child support works in Ontario. Hopefully you learned something you didn't know before and found some useful insight. As always, it's important to remember that this video is not intended as legal advice, and you should always speak with a qualified family lawyer if you have questions about family law in Ontario. Don't forget to like and follow on Facebook and subscribe on YouTube. You can also follow me, Ryan Keeney, on TikTok. Bye for now.